Get on the ground, you're gonna get tased! You're gonna get tased! Get on the ground now! Get on the ground, get on your stomach! Get on your stomach now! Get on your stomach! You're gonna get tased if you move. St. John's, I'm working on getting her secured.
On the 8th of September 2023, a St. Johns County deputy conducted a traffic stop in Street Augustine, Florida. On a driver suspected of DUI, what began as a routine stop escalated into a felony flight, a crash, and an arrest captured in full on bodycam.
Hey, how you doing tonight?
Good, how are you?
Simple. Hey, I'm Deputy Green with the Sheriff's Office. Hey, reason I'm stopping you, okay, first off, alright, when you were stopped over there at the red light after coming over the Bridge of Lions, okay, you were stopped way past the stop bar, and your car was completely in the crosswalk.
Okay.
Okay, you can't be parking in the middle of the crosswalk, because if people are trying to cross, obviously, they can't walk through your car, right?
That makes sense.
Okay, as you were coming down Cathedral over there, okay, do you remember where you started drifting over to the left?
Yes.
And you almost hit that parked car?
Yes.
Okay, and then as you turned here, alright, you turned here very quick onto this road, which is King Street. Okay, so that's why I stopped you. One, you were parked in the crosswalk up there. Two, you drifted over and almost smashed into that parked car.
I did not almost smash into the parked car. I'm a Lyft. I'm trying to get to my customers.
Okay, do you remember, but you remember almost hitting it?
No, I didn't almost hit it.
Well, you just told me that you did.
I did not. I said I moved over to the lane, and all of a sudden, I was in the lane where I was trying to move over. There's a parked car that's in the middle of the white line in the lane.
Right, but you started drifting over, almost hit it, and you swerved over to the right.
That's not what happened.
Okay, well listen, I'm just telling you what I saw. Okay. And also, parked in the crosswalk. Okay, do you have your driver's license, your registration, and insurance?
I sure do. Can you give this bear with me?
What's that?
I said, can you bear with me?
I didn't even say anything.
It's the light.
It's just my light.
I know, but it's a little invasive.
It's not invasive.
It is.
What are you... St. John, she's taking off. She's heading towards... She's clicking right on St. George. She's single too. Cathedral. I'm on Cathedral. I just lost her. It looks like 1023. She's signal forward. She's running. Get on the ground. You're gonna get tased. You're gonna get tased. Get on the ground now. Get on the ground. Get on your stomach. Get on your stomach now. Get on your stomach. You're gonna get tased if you move. St. John's, I'm working on getting her secured. I can't give you an address. We're in a side yard. Put your feet out. She's not secure yet. I'm working on it. Put your arms behind your back.
I've never done anything like this. I'm scared. Please.
You just made a bad decision.
I know, but I'm
Sit up.
scared.
10-4. I'll give you an address in a sec. If you keep going north on St. George, you'll see a tree in the road.
Hold on, give me a second. Please, I'm scared. I'm such a good person, please.
St. John, start fire rescue. Her motor's on fire. You done messed up.
I'm sorry.
Look, your car's on fire.
I understand that. I've never done anything in my life.
Yeah, well, you made a bad choice.
What happened? Please tell me what happened.
What's happening? Look what you just did. Look what you just did.
Okay,
Look at all
so
this.
One bad mistake makes up for a...
Do you got anything illegal on you?
No, of course not. No, of course not.
Take a seat.
Well, you have a strap.
Take a seat. St. John's, I got the fire out. If you can keep fire rescue coming, just check the vehicle and check my subject.
We have posts, paneling, vehicle headlight, Toyota. Oh my gosh, it's in their yard.
This thing like exploded.
I love that you guys got dressed up. It brings me joy.
Oh my god.
Isn't that some Final Destination right there?
Holy shit. Wow. Morning. Hey, tell me what's wrong with that picture.
Yeah, she's getting on the plane tomorrow, and that's
Oh my.
that'll be the end.
Look at that.
That's
crazy.
Final Destination.
Yeah. Fuck.
Dude, that would have hurt a passenger.
Have you seen that movie?
Oh yeah.
Okay. I was gonna feel really, really old if you didn't.
It hit the fence?
She hit a lot of things, so we'll get some stuff out of your yard and whatnot.
Oh my
but
gosh,
just,
it really is in my yard.
yeah, it's everywhere, and then there's some up here too.
Wow, oh my gosh.
Yeah. How's your knee feel?
I just up. I'm fine. I'll heal.
Okay. Can I see your face real quick? I just want to check to see if you're okay. I'm gonna pull that leaf out of your hair. Oops, sorry. Okay.
No, it's okay. I have a 3.5-year-old and a fiance.
Are they home right now?
Yes.
Okay.
I just want to let him know I'm okay. I've never been in trouble. I got scared. I know what I did. I know I made a mistake.
I just got here, so I don't even know what happened. So
He pulled me over. I've never been pulled over in my life. I'm 30 years old. I got scared.
well, I'll go let Deputy Green know. What kind of phone do you have? Is it iPhone, Android?
It's an iPhone.
Okay. What's the phone background? So if they see it, they know it's yours.
Me and my daughter.
Okay, so it's you? Your face? Okay. I'll go let them know, okay? I'll be right back.
Anytime until you talk to a lawyer. Do you understand your rights?
Yes,
With your rights in mind, are you willing to answer some questions for me?
given. Yes.
I don't understand what that meant.
Yes.
Okay. When's the last time you slept?
9 a.m. this morning.
Like, that's when you woke up?
Yes.
Okay. How many hours of sleep did you get last night?
10.
How many?
10.
When's the last time you ate?
6:30
6:30?
p.m.
What'd you eat?
Mac and cheese and asparagus and kielbasa.
Okay. And without looking at a watch, what time do you think it is right now?
Probably 2:45.
From the time that you woke up this morning to us talking right now, have you consumed any alcoholic beverages?
I met up with some friends at 9:30.
Okay, so about 9:30 you met up with some friends. What time do you think you had your last alcoholic beverage?
I don't know.
You don't know? Okay. And
This is the first.
I understand. It's quite a first.
No, this is a big
It's a big first, yeah.
first. But I got scared.
So
I'm
about a
sorry.
total of how many alcoholic beverages do you think you've had?
I wouldn't know.
You don't know? Okay. And let's see.
I decline to answer.
Hmm?
I'm
You don't want to answer any more questions?
I'm not sure about that.
Okay, that's fine. So here's the deal. You are being placed under arrest for DUI as long as a lot of other charges. Okay?
Correct.
I am requesting you submit to a lawful breath test to determine your breath alcohol content. Is that something you'd be willing to do for me?
No.
Okay. I gotta read you what's called your implied consent, okay? Okay, and you still refusing a breath sample?
Yes.
Hey, is this Kim?
Yeah.
Hey, Kim, it's Deputy Green, St. Johns County Sheriff's Office.
Okay.
Hey, I'm here with your daughter, Ali Alexandra.
Okay.
She got herself in a little bit of trouble tonight. She's okay. She was driving impaired. I stopped her on a traffic stop, and she made the wrong decision to flee from me. Drove a very high rate of speed, in the city, crashed through 2 separate yards, took down a power pole as well as somebody's oak tree in their front yard, and totaled her vehicle. And then she ran from me on the foot. So, she's got herself in a little bit of trouble tonight, but she wanted me to call you, just to let you know what's going on, and so you know that she's okay.
Yeah, that's, I don't know. She made a bunch of bad decisions. Closer. She's a very responsible girl.
Yeah, she seems like it. She just made a very, very bad decision tonight.
Not a total piece of shit.
I didn't say you were, you just made a mistake.
The stop was legally grounded in 2 independent observations. The vehicle stopped past the stop bar into the crosswalk, violating Florida Statute Section 316.075, and drifted into an adjacent lane, nearly striking a parked car in violation of Section 316.089, under Delaware v. Prowse, 440 U.S. 648. Law enforcement must have reasonable, articulable suspicion of a traffic violation to conduct a stop. 2 violations observed firsthand, independently, more than satisfied that standard. The stop was constitutionally sound. The subject disputed the lane drift observation at the window. That dispute is legally irrelevant at the stop stage. The Fourth Amendment requires only that the officer's suspicion be reasonable, not that the subject agree with it. The deputy was not required to resolve the factual dispute before proceeding. The subject's voluntary statements during the stop, before formal arrest, before Miranda, are admissible under Berkemer v. McCarty, 468 U.S. 420. Traffic stops are not custodial for Miranda purposes. Anything said at the window is fair game for the prosecution at trial. When the subject chose to flee, the legal framework shifted entirely. Under Florida Statute, Section 316.1935, subsection 3, fleeing at high speed or with wanton disregard for the safety of persons or property is a second-degree felony, carrying a potential maximum sentence of 15 years in prison. The subject reached 70 miles per hour in a 20-mile-per-hour zone, 3.5 times the posted limit, and nearly struck 2 pedestrians who had to jump clear. Under Illinois v. Wardlow, 528 U.S. 119, flight from law enforcement is legally significant conduct. Here, it constituted an independent felony. The vehicle crashed through 2 separate residential yards, severed a utility pole, and destroyed a large oak tree before catching fire. These property offenses carry additional exposure under Florida Statute Section 806.13, criminal mischief, with felony classification depending on the assessed value of damage. After the crash, the subject fled on foot. The deputy issued a taser warning, a less lethal threat, consistent with the use of force continuum for a fleeing subject. Under Graham v. Connor, 490 U.S. 386, the reasonableness of force is judged from the perspective of a reasonable officer on the scene, not in hindsight. The warning was legally appropriate. The taser was not deployed. Once the subject was secured and formally placed under arrest, Miranda v. Arizona, 384 U.S. 436, required full advisement before custodial interrogation. The deputy complied. The subject confirmed understanding, agreed to answer questions, and then mid-interview, lawfully and clearly, invoked her Fifth Amendment right to decline for. The deputy ceased immediately. No violation. The subject then refused the breath test. Under Florida Statute Section 316.1932, the implied consent law, any person operating a motor vehicle in Florida is deemed by law to have consented to a chemical breath test upon lawful DUI arrest. Refusal is not without consequence. It triggers an automatic 1-year administrative license suspension and is admissible at trial as evidence of consciousness of guilt. The subject was initially charged with 8 offenses. The state reduced that to 4. She was released on a $13,000 bond, entered a not guilty plea, and demanded a jury trial. The case remains open. The likely charges proceeding include DUI under Section 316.193, felony fleeing and eluding under Section 316.1935, and related property and reckless driving offenses. Now to the grades. Deputy Gary receives a grade of A-. The traffic stop rested on two legally independent bases, either of which alone would have satisfied Delaware versus Prowse. 2 is stronger. The deputy's legal foundation was sound from the first second of the encounter. During the pursuit, radio communications were clear, composed, and continuous. After the crash, the deputy located the subject on foot, issued a lawful, less lethal warning, achieved compliance without deployment, and simultaneously managed a vehicle fire, personally extinguishing it before fire rescue arrived. That is above standard scene management under pressure. Miranda was administered correctly. The subject's mid-interview invocation of rights was honored without hesitation or coercion. Implied consent advisement followed procedure. Post-arrest conduct, checking for injuries, calling next of kin, speaking with patience and dignity, reflects a high standard of professional care. No constitutional violations identified. 1 deduction. The repeated verbal dispute at the window over whether the subject almost hit the parked car was tactically unproductive. Once a subject disputes a factual observation, the correct response is to note the disagreement and proceed, not to relitigate the point before the stop escalates. Minor friction. Significant timing risk. Ali Alexandra receives a grade of D. The original violations, crosswalk and lane drift, were minor traffic infractions. A first-time DUI stop, while serious, is manageable with legal counsel. The flight is what made this case a felony. Every charge beyond the original stop exists solely because of the decision to drive away. The subject reached 70 miles per hour through a residential zone, nearly struck 2 pedestrians, crashed into 2 private properties, downed a power pole, and fled on foot after the crash. Under Florida sentencing guidelines, a second-degree felony conviction alone carries up to 15 years. Panic is a human response. It is not a legal defense. Credit where it is due. Once apprehended, the subject complied without physical resistance. She answered questions honestly before lawfully invoking her right to silence. Her breath test refusal, though administratively costly, is a protected right. These post-arrest decisions were legally appropriate. Lesson 1. Never flee a lawful traffic stop. Under Florida Statute Section 316.1935, the moment a driver accelerates away from a lawful stop, the original offense becomes secondary. Flight is its own felony. No traffic violation carries more legal risk than the flight that follows it. Lesson 2. Voluntary statements before arrest are admissible. Miranda does not apply at the roadside. Under Berkemer v. McCarty, anything said during a traffic stop, admissions about drinking, about driving behavior, about the night's events, goes directly to the prosecution. Lesson 3. Implied consent is not optional. Driving in Florida is a statutory privilege. Refusing a breath test after a lawful DUI arrest costs a 1-year license suspension and hands the prosecution evidence of consciousness of guilt. The refusal itself becomes part of the case against you. Lesson 4. Know when to stop answering questions. The subject's mid-interview invocation of her Fifth Amendment right was legally correct and was immediately honored. Stating, "I decline to answer," calmly and clearly, is one of the most effective tools available to any person in custody. It cannot be used against you. Lesson 5. One decision multiplies into many charges. The subject entered this stop facing a crosswalk infraction and a possible DUI. She exited it facing 8 charges, including a second-degree felony. The flight, the speed, the crash, the pedestrian endangerment, the property destruction, each was a separate count. Each was avoidable. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.